Hi, everyone. Welcome back to Crime in Court. We are reading through the Delphi trial transcript, Indiana versus Richard Allen in the homicides of Libby German and Abigail Williams. We are on the state's case part 25. Melissa Oberg is currently still on the stand during her cross examination. Brad Rosie for the defense is doing the questioning for the defense, and we just came back from a sidebar conference where Brad Rosie was going to pull out he was going to demonstrate the firearm or pull out the firearm and display it for the jurors. And the court said, no, you're not the expert. So I'm going to have Melissa Oberg touch it or, handle it. And then he's like, well, does she need gloves? Okay, never mind. So he's like, I'll back off. So he's like, I'll just move on. So now we're back in front of the jurors, continuing on his uh, examination regarding her investigation of this gun, what she did to examine this firearm, and the ballistics involved in this case. So let us continue. Please hit the like button if you haven't already done so. Thank you very much, and let's get started. All right. This firearm, when you got that firearm and you started your examination, one of the first things you did, of course, you checked to make sure it wasn't loaded, right? Correct. Then you cycled it, didn't you? I don't know that I went directly into cycling it. Basically, I'll take it out, make sure it's not loaded, and then I'm going to do any of my examination process where I'm typing notes, looking at is there any biological material or anything adhering to it. At some point in your examination, you got those test fires out of your stock safe, right? I got the test fires out of an ammunition box, which we have ammunition boxes sitting on shelves that we use for test fires, for test firing purposes and cycling purposes. So they keep them for those, just to cycle them or fire them. Okay, and you started cycling rounds, right? I didn't just start randomly cycling rounds. I actually have to do a function exam of the firearm at first, and then after that function exam is complete, then I will cycle and test fire. And in this case, since I had two magazines, I had to use each magazine. So 6 cycled rounds? That's correct. You noted in your report, page 7, that the cycled cartridges have some extractor mark areas and limited to no ejector marks, right? That's correct. So extractor marks and no ejector marks, or limited to no. So few or none. She says that's correct. Okay, and that's a summary of your findings with regard to the cycled rounds. That's correct. You didn't offer up any information about what you found on each of those 6 cycled rounds, did you? Not individually, no. So I summarized it. So you had 6 rounds in front of you, cycled them all through item 314, right? That's correct. And you said, I found some extraction marks and no ejector marks. I said cycled in here. Cycled cartridges have some extractor mark areas and limited to no ejector. So that means that some would possibly have the potential to have ejector marks. Not all of them exhibited ejector marks. You don't know what rounds had what marks? I know by the evaluation of looking at them, but I don't specifically say 1, 2, 3, 4 had it or so forth. No. So it's not referenced in your report, correct? No, it's not. It could have been one round with one ejector mark and the other 5 without. Basically, when I'm saying limited, it could mean more than one. But what we do know is that the results when you cycled each of those rounds were different. Basically, it's not that it's different per se, it's just the veracity of those marks and availability of them is less than what I saw when it was test fired. So you didn't get the same marks. Got it. Okay. That's another way of saying that. We also know that the marks that were generated on those six cycled rounds were different than the marks that are on the item 16, right? I don't, it's not similar. How are they not similar? Well, you didn't use them to draw your conclusions, did you? I didn't use them to draw my conclusions, but I didn't say that they were dissimilar. You didn't use them to draw your conclusions? No, I did not. So at that point, you've got a firearm that you, or a round that you know it's only been cycled. You test cycle 6 rounds. You got not enough information out of that gun, 314, to move forward with your examination, do you? As far as being able to move forward, I could move forward with the test fires. I chose to use the test fired ones because they did mark better than the cycled ones. So this is a case of work smarter, not harder. That's not what forensic science is about. Working smarter, not harder. Aren't you supposed to make sure that you're being accurate and consistent with what you're testing to what you're using? Okay, they were different, weren't they? They weren't different. They were just, they had more veracity to them. They had additional markings that were available. So I'm getting the complete picture when I'm seeing them fired versus cycled. How can you say you're getting the complete picture when you don't even know if it came from that gun? It's ridiculous. So the test cycled rounds were not exactly the same in terms of their markings as the test fired rounds, were they? They were not the same in the depth and the actual availability of them, but it's not that they're different, it's that they did not mark as well. So they were different, in other words. I don't consider them different. To me, different would mean that they look completely different in the sense that they don't go at all. Like, I guess that's where we're having some terminology issues here. But different to me means so I saw a circle in one area, and in this area, I saw a triangle. To me, that means different. So they weren't different, there just weren't enough of them. So a lack of marking is evidence. You firing it through the gun to make sure that you have those markings that weren't there through the cycled round, that's pretty much making the evidence fit what you want it to say. And to hell with science and to hell with doing things in an accurate and fair way. So you chose not to use the cycled rounds. That is correct. Yes. Did you also compare chamber marks and magazine lip marks on the test cycled rounds in 16? Yes, I did. And there was no significant agreement between those marks, were there? No, there were not. More differences between the test cycled rounds than and that item 16? More differences? I'm not sure what you mean by that. Well, there was no sufficient agreement, right? There was no sufficient agreement in either cycled or test fired for that area. Sorry, we had to change transcripts. It just cuts off in the middle of people's testimony for some reason. And you had these clips in the magazine, right? Or not clips, these rounds in a magazine. Yes, I did. Some people call these clips, right? Yes, they are not indeed clips. They would be that would be a slang term. A clip is actually different. These are only magazines. Did you compare any of these rounds in these magazines with either one of those two closet rounds? No, I did not. And did you compare any of these rounds in the two magazines with item 16? No, I did not. So these rounds were collected with the hit this firearm. I don't know if they were collected together or how they were collected. I just know that I received them together. So then you test fired 4 rounds, correct? That's correct. And you examined those rounds under, is it a stereoscope or a microscope? I hate to get too lax about that. I examined them both underneath a stereoscope and a comparison microscope. You didn't document any of that examination in your report, did you? So, the test fired round. The examination part of the test fires are on page 7, and that would have been when I was examining them underneath the stereoscope. So the paragraph about cartridge cases, and even the bullets below that. That is what the test fires look underneath stereo. That is what the test fires look like underneath a stereoscope. So that's the documentation there. I also further on page 8. Well, hold on. There's no further question. Mr. Luttrell says, Your Honor, he asked a question. She's still in the middle of answering it. The court says, let her answer. She says, further on page 8, there is also documentation where I talk about test to test. I say 314T1 and 314T2. This comes after the comparison microscope performance test, and I say where I evaluated the test fires to each other. Well, you told me back in March that you did not document in your report your viewing of those test fires, didn't you? Well, it depends if you're talking about the certificate of analysis or if you're talking about the actual notes themselves, so it could be misconstruing what's actually being talked about. If I direct your attention to page 127, would that help refresh your recollection, specifically lines 1 through 3 and then lines 14 through 16? Well, 1 through 3, that's it looks or appears that we're talking about the cartridges that I would have fired in the firearm. Well, on page 126, I direct your attention to page 126, line 21. I'm not going to try and read it. I'm referencing. Yeah, one of the rounds that you pulled out of your collection, right? Yes, you are. So I'm talking about your stock rounds. Yes. And that's what we were just talking about a minute ago, right? You're talking about, so I can't understand you. You're flipping back. I'm just trying to clarify. Okay, please. I asked you if you look at any of your stock rounds under a microscope, right? Yes, you did. And on page 127, lines 14 through 16, my question to you is, would you have documented that somewhere that, hey, I examined those and they were clean? And your response was, I did not, correct? What page are you talking about, Mr. Rosie? Asks Mr. Luttrell. He says 127, lines 14 through 16. The witness says, yeah, what you're talking about right now is different than what we're talking about, or at least that I was interpreting earlier. I'm thinking test fires, as in I test fired them. Did I document anything about them? And you're talking about test fires before I even test fire them. No, he's talking about the same bullets that you used for the test firing, did you look at them before you fired them? Is basically the question. And she's being so evasive and doesn't want to answer it. He says, yeah. She says, okay, so we're not on the same page. So, no, I do not document that I took those out and I physically examined them in my notes. But yes, I do document when I test fire them. So, the actual test fires. But you have nothing to compare it to prior to the firing of the bullet when you're trying to see if there's markings, you need a before and an after, right? He says, okay, but not before that. No. All right. And now there's a reference to, we're talking about comparison of item 16 with your test fire 1. You understand that? That's the context in which we're talking? Okay. You understand that? Yeah. And there is a reference to chamber and lip marks on item 16, right? Where are you referencing this at? Page 9 of 14 of your report. Okay. So, in other words, this round has chamber lip marks. You documented it. It has the marks of the side of walls of it. They could be indicative of chamber lip marks, but there's no significant agreement between those marks on that round and your test fires, is there? Objection. We don't know what that round is, says Mr. Luttrell. He says, I'm pointing at 16. Mr. Luttrell says, I can't tell. And the court says, nobody can tell what you're pointing at, sir. You have to. Mr. Rosie says, well, we were just talking about it. It's sitting right here. It's kind of obvious. The court says, well, it's not obvious for the record, which is a written record, sir. Is that necessary? Mr. Rosie says, I'm sorry about that. I'll try to be more inaudible. We've got our first inaudible 16 minutes in. These inaudibles are ridiculous. Number 16, right? Correct. Yes. I was not able to. So there was no agreement between the chamber and lip marks on your test fires with that round. That's correct. So those marks on the test fire were not helpful in making any determinations about item 16. That's correct. And those would be an example of the kind of markings that could be possibly be made in the factory subclass, right? The magazine lip marks? Yeah. You can have subclass in them, yes. Okay. You also didn't find any similar chamber marks on the test fired rounds and item 16. That's correct. So here he's pointing out all the things that were not consistent, weren't sufficient uh, matches or whatever the terminology is, sufficient something or other. Um, he says, one second. Is it possible that the differences that exist between the test fired rounds and item 16 are the product of the test fired rounds being fired and not just cycled? Like, is it possible that what we're actually seeing is because it's being fired and not just cycled through the gun? She says, from what I saw when I observed the marks on the side walls of the cartridge case, and I had stated to this earlier, there is not a lot there to work off from the very beginning. So there isn't enough that it would be that it would ever be able to be identified or back in that area. But I didn't see any similarities as far as like a sufficient amount of agreement in that area. Now, as far as whether it's being cycled or fired, I would expect there to be less to be able to even compare with the cycled versus fired. What kind of word salad was that? So there's a lot of words. My question is, so he thought it was a word salad too. My question is it possible that the difference between the test fired rounds and item 16, the marks on item 16, are the product of one being cycled and one being fired? That could be possible, yes. She has to admit that it's a possibility that the reason we're seeing the differences is because one's fired and one's not, which makes all the sense in the world to everybody else except the Indiana State Police and their crime lab and the people that work in it, apparently, and the prosecutors and the judge. Am I missing anybody? Law enforcement? Yeah, I don't know. That's about it. You told me, yes, that is a potential, is what you told me before, right? Yes. Two different environments, two different results, right? The way it goes in the way it goes in is the same way. It's just whether the pressure is different between the two. Not whether the pressure is going to be different between the two, firing and cycling. So yes, what kind of answer is that? He says, Rosie says, two different environments, two different results. I will keep on repeating it that it's the same area, it's just whether the pressure is greater or not. Two closet rounds and the test fires, you didn't really do any comparison between those two sets of items, right? No, I did not. Excuse me. So this round, item 315, which is similar to item 16, you didn't compare this with any of your test fires? No, I did not. And you cannot tell the age of any of those rounds, right? No, I cannot. Objection. That's been asked and answered. No, it hasn't. I'm sustained. May I rephrase the question? The court says, yeah, because it's been asked and answered. He said, do you know how long those marks have been on those bullet casings? That's a different question. With regard to items 315 and 316, you don't know the age of the rounds? No, I do not. You don't know when they were manufactured? No, I do not. That's actually another aspect of the firearm identification business is trying to age rounds, isn't it? Not in my line of work, it is not. Well, there used to be a thing called comparative bullet lead analysis, right? There was, and that was conducted by the FBI. All right, the FBI laboratory. Yes. And they were taking the lead or the metal in those projectiles and trying to make determinations about when those were manufactured. They were trying to determine if they could figure out whether it was coming from a specific lot of ammunition. All right, let's talk about that. You mentioned lots earlier, didn't you? Yes, I did. Lots being that, hey, when they make ammunition over in Springfield, Ohio, or Missouri, they make they might make 1 million rounds in 2007. They might be a lot of if it comes off the same floor, right? The same assembly line. Well, typically, lots don't span for that long, but there are larger numbers in that area, could be around 20,000 or so forth. It just depends how long the machining lasts for that. Okay. They have to change tools because they get worse? Yes, they do. And these are the tools that make these rounds that wear down. Yes, that is correct. They change, they wear down, which is change, correct? Correct. Okay, so that comparative bullet lead analysis was a discipline that people were using in courtrooms around the country, wasn't it? Yes, they were. And at some point, not super long ago, that was kind of debunked, wasn't it? This is great. Well, it's been about 20 years. Okay, well, they're not doing it anymore, are they? Well, and it's not the science itself that it's debunked. It was the statistical analysis that they were using to give their conclusions. People were walking into courtrooms and testifying about that stuff, weren't they? They were. FBI agents and laboratory agents, right? Well, I don't know the status of them, but they were laboratory personnel. And they found out, oh, we shouldn't have been doing it, right? They shouldn't have been assessing them with the statistical analysis that they were using, was not per se enough to limit it down to where it should be. So they're not doing it anymore? No, they are not. Judge, would you like to take a break? Court says, no. Rosie says, thank you. So let's talk about the time period between 2017 to 2022 as it relates to item 314, which is the firearm, okay? Okay. You agree that it could be true with any tool that it could create different kind of tool marks over different periods of time. I would say that it can occur. It could change based on the number of rounds that are fired, though. or that are fired through it. Typically, it's a sustained amount of time that it could happen, and so it typically takes a lot of rounds to start altering a firearm's ability to change that. So I can't give you a specific number other than that we've studied some of that. We've looked at 10,000 round tests, and we've also studied them in black box studies. You don't have any idea what happened to that gun, what environment it was exposed to, how much it was used between 2017 and now, do you? No, I do not. And you agree that the tools in the firearm could have changed over time based on that use or exposure of the environments it was susceptible to. It's possible. It's a great point. You don't know that this gun was in the same condition back in 2017 than it is today in 2022. Would it have even left those marks back in 2017 that you're saying it left? Cycled or fired. It could be totally different based on what he just said. Over time, the inside of the firearm can change. So the marks that that firearm's making now may not have been the same marks it was making in 2017. So if I'm able to identify it back to it, then it is still making marks that are representative of that. So if it was making different marks, I would not have been able to identify it back to it. So it's different now than it was then, right? Different in what way? It's been used. It's different. It's been used, but I can't tell you that the marks have changed. There's another side to this argument, and that is that those tools are quality tools, right? Which tools? Well, the ones that Sig Sauer makes. Sig Sauer makes quality firearms. They're a reputable firearm company, right? They are. I love how he like sets her up to fail. Like he's backing her into a corner. You know it. The way that he does his examination. I like it. So Sig Sauer makes quality firearms. They're a reputable firearm company, right? They are. They've even got little videos, 5-minute videos that hold themselves out as that, right? There's videos out there that you can watch. So the idea in that aspect is that they create these really great tools and they don't change over time, right? Well, they are durable basically. So if that's the case, then you would expect item 314 with those high quality tools to impress the exact same marks in 2022 as it did in 2017? I would expect some similarity to be there, yes. And when you cycled rounds through that gun when you first got it, those rounds were not adequate to assist you in making a determination about the bullet and that gun, were they? No, I did not feel that they were. You're not sure when the gun was manufactured either, are you? No, I do not know the exact date. You don't know when the last time that firearm was cycled, right? No, I do not. Now let's talk about the subclass characteristics for a minute. One of the most important things that you do in this line of your work is to evaluate and understand subclass characteristics from individual characteristics, right? That's correct. I'm getting casual, but I would say that's kind of where the rubber meets the road in your industry, isn't it? Yes. It's pretty easy to identify a class characteristic, right? For the most part. Is it a Ford? Is it a Chevy? Those kinds of things. Yes. But when it gets down to subclass and individual characteristics, that's really where you're spending the majority of your time. That is correct. And in this case, there were really three tools in that firearm that were significant to your findings, right? Ejector, extractor, and barrel hood. That's correct. And you investigated or evaluated, trying to think of the right words, the ejector for subclass characteristics. That's correct. And you were not able, well, let's put it the other way. at the conclusion of your investigation, there was still potential for subclass characteristics? Yes, there were definitely subclass characteristics present on the ejector itself. And you kind of mentioned this earlier, but that particular tool itself, just alone, the standalone tool, the ejector, is not adequate enough to draw any conclusion. Some people will draw conclusions on it, but I did not feel comfortable in this case drawing only conclusions on the ejector mark alone. The extractor, you also concluded that there could be a potential for subclass characteristics, at least in part, on part of it, right? With the extractor, I wasn't able to observe the actual tool itself. Now, the impressed marks that was on the underside, impressed marks in general can lend themselves to subclass characteristics. I noticed a bumpy, wavy surface there with the ejector, and so it did not appear to be subclass, but impressed marks in general can lend themselves to subclass. So you could not exclude subclass characteristics with the extractors? I could not exclude them as far as it being an impressed mark. However, with the striated portion being there, I could rule that out from being subclass in nature. But there were still subclass characteristics potentially, right? There's potential, yes. Did you actually physically examine the extractor surfaces like you did the ejector? No. You spent a lot of time on the ejector, right? Yes, I did. And then with that chamber face, there's really no peer-reviewed research at all with regard to subclass characteristics with that third tool, is there? So the third tool I do know was manufactured with milling. That's been stated several times at this trial, so it's milling in general that you're looking at to see if it has a potential for subclass. In this case, that area comes to a corner which I showed you guys earlier. So the marks, Judge, I would ask the court to instruct the witness to answer the question. She's just talking. I asked her about peer-reviewed articles. Mr. Luttrell says she is answering the question, and the court says, I think she's answering the question. No, she's not. She didn't say anything about peer-reviewed articles. She's talking about other things. Mr. Luttrell says, no, she directly tied it to peer-reviewed articles on milling of the tools. Mr. Rosie says, may I ask the question again, Your Honor? She still, let her finish her answer, says the court. So that area that I saw there is directly tied to milling. I presented several articles about consecutively made milling items today and how examiners can tell the difference from them. That is an area that I knew how it was manufactured. I knew that it came to an area where it comes down to a V area, and I'm actually looking at two surfaces that are coming together. In firearms identification, when that happens, those marks are typically individual in nature. Okay. Are there any peer-reviewed studies for subclass characteristics for chamber faces? Peer-reviewed. It's not the mark or the tool itself, it's the tool that made it. So it's the milling process, it's not the actual tool. They're two different things. Are there any peer-reviewed studies? Yes, there are peer-reviewed studies that you're aware of. Peer-reviewed studies on what? Chamber faces. Just mentioning directly chamber faces? No. Thank you very much. Whoops, sorry about that. He says, you're welcome. Or she says, you're welcome. So there's only a breech face in one of those in that firearm, right? That's correct. I think it was on maybe one of the slides you presented. That's correct. That would be another area, kind of. Is that a tool technically? Yes, it is. Okay, thank you. You were not able to use that tool to draw any conclusions in this case, were you? No, I was not. There were not adequate marks made by that tool? Well, this is an unfired cartridge, so typically breech face marks don't show up in cycled marks on a cycled cartridge. They can, but typically not. But they can? Yes, they can. But we didn't have that here. No. So you generated some. Excuse me, I'm getting quite a bit far over here. You generated some microscopic images, right? Yes, I did. And I'm showing the jury and trying to show you, ma'am, items K, defendant's exhibit KK. You see that? Yes. I'm just going to take, this would be your test fired round 315T on this side, the left side, compared with item 16, right? That's correct. Now, this is a microscopic image at 60 times, right? Yes. Is that, how would you say that? Yes, 60 times magnification. Thank you. And what you're looking at here, and I'm kind of pointing here to the top portion of the exhibit, you've got two images and the hairline in the middle, and one side of is the test fire and the other side is item 16, right? That's correct. And you made a determination that there is some sufficient agreement between both of those sides to draw your conclusion? I did, yes. And so what you're saying is that there are similarities between the left side and the right side that you can rely on the in this matter. Objection, Your Honor, and ask leave to ask a preliminary question. Court says you may. Mr. Luttrell says, what Mr. Rosie is showing you is a photograph of that portion of the that comparison process. Is that correct? That is correct. But is that what you're looking at? And when you're looking through the comparison microscope, that image that he's showing you? It's the image that is taken at the time of the examination, but it's not everything that can be seen. And so, would it be misleading to offer an opinion based upon the photograph itself? Well, the photograph itself is not going to show you everything. It'll just show you what I could see during the picture time process. I would object to the question, Your Honor. I think it would be misleading to the jury. Mr. Rosie says she didn't say it would be misleading. She just said she'd see more, so it goes to the weight. The court says, I agree. It just goes to the weight rather than she answered, she may answer. Well, let's just talk about this photograph. Okay. Well, actually, there's several photographs here, some of them similar in terms of their microscopic images, right? Yes. I mean, they're of different things, but they're similar in terms of what they're looking at the lab, right? Yes. Now, when you offer up a lab report to the prosecutor's office, they don't get these, do they? No, they do not. And we've talked about this earlier, but they can be obtained, but we gotta ask for them, right? That's correct. This is basically me saying, hey, show me your work, right? That's correct. And I want to see what you've generated in terms of work product that you use to draw your conclusions, right? It's representative of the work product, yes. And this is what you gave me? That's correct. Do you have something else in your file in terms of images that you did not give me? No, I do not. Okay. So it's fair for me to use these to make determinations about what you're seeing, right? Well, you can do that. I can't sit there and make determinations based off of a photograph. Well, is it okay for the jury to use these to make their own determinations? It's okay for the jurors to observe them, but to make a determination as to specifically what I saw at the time and throughout the entire process, it would be unfair. Huh? Okay. Why don't you just take pictures of it from all angles then, if that's, I mean, seriously, why is this so difficult? So we just need to believe everything you say because you're sitting here testifying, right? Objection to the question. Sustained. Mr. Luttrell says it's improper. Is it okay for these jurors to use your work product to draw their own opinions about their conclusions, about your conclusions? Let me rephrase that or restate it. Is it okay for these jurors to use your work product to draw their own opinions about your conclusions? It's fair for them to do whatever they need to do to make a decision. And one of those things would be looking at those photos, right? They can look at those photos, yes. So this first photo, items KK, again, the top right corner here is where the hairline is, right? That's correct. And your position is that there's some sufficient agreement between these two surfaces? Mr. Luttrell says, to which I would object and ask leave to ask the preliminary question. The court says, you may. Mr. Luttrell says, would a trained and experienced firearm tool mark examiner use the photos to make a determination? No, they would not. Do you think it would be wise for the jury, if they are trained and not experienced in tool mark examination, to draw conclusions from these photographs about your analysis? Well, they would not be able to draw the same conclusions as I would because they are not trained as examiners, but they can observe them. Miss Rosie says, may I continue? Mr. Luttrell says, Your Honor, I would assert that this would be misleading to the jury and inappropriate cross examination. Based on her answers, it would be misleading, so I'd sustain it. Seriously? Using her own work product, based on her answer, would be misleading? Mr. Rosie says using her own work product would be misleading. Court says based on her answer that she just gave that she would not just use those photographs. These are part of what you use to make your determination, right? The photographs are not what I use to make a determination. The photographs are what I use to memorialize the process. So I don't use photos to make any determination. I try to do the best to capture an image of what I'm seeing, but I cannot give you all of it. It's the same thing I explained before. You don't get to see the movie. You're only getting to see what's memorialized at that time, that area that I looked at. So these are the things you memorialized. Yes, item KK, right? That's correct. I'm assuming you go and take pictures of the areas that you think are significant, right? The areas that I take pictures of are the areas that I used in the process to coming to my determination. So the areas that are depicted in the image is what she used to make her determination, but the images themselves cannot be used as a determination. Okay, got it. So, huh? Yeah. Maybe I don't got it. I don't know. Um, he says item LL is one of those, right? That is correct. Item MM. That's correct. Sorry, trying to get the dog under a blanket and read at the same time and scroll is not easy. It's not that I make a determination off of them. I take the photo of it so you can see the area that I would use to make a determination. So the picture is an image of the area that you use to make your determination, but we can't use those images to make a determination, we the jurors. Why exactly? So item MM, same same question, same answer. That's correct. Hairlines right here, the middle. That's correct. One surface, the other surface. That's correct. Item OO, same question, same answer. That's correct. Let's talk about item OO for a minute. You had a chance to look at that. Yes. This is a copy, or this is an image, is it not, of the ejector mark on item 16 on this side and test fire on that side, right? That's correct. And would you acknowledge, or do you acknowledge, that there are some similarities between those diagonal lines on both sides of that hairline? There are some similarities, yes. Those are subclass characteristics, aren't they? These do not appear to be subclass characteristics to me. They do not span the entire length of the surface area. The subclass characteristics actually go in the opposite direction. If you want me to show you in a picture, but again, that would be me doing a comparison here. It wouldn't be helpful for you to use your own picture to show anybody, would it? Mr. Luttrell says, Your Honor, I would object if the implication she's made it clear why the photograph is not something she uses to do an examination, and she's made that very clear. Mr. Rosie says, I'll move on. And the court says, Please move on. You could not exclude subclass characteristics with the ejector mark in this case, could you? There were subclass characteristics present on both the ejector and in the area, not in the area, but adjacent to it. You could not exclude the subclass characteristics, could you? These are subclass characteristics present. The last photo, PP, right? Yes. We talked about the verification process earlier. Yes. You started your examination back in October 17th, right? That's correct. And you finished this 2 days later on the 19th. That's correct. Actually, you worked on it. I think you told me at the depot to look over 3 days. It took you over 3 days. Yes, that's correct. And that was your primary focus during the 3 day period. That's correct. The verification process that you talked about with your boss occurs in your presence, right? You're there at the lab? I am there present, yes. So it was the same day that you finished your 3 day investigation. The verification process actually occurred the day before I wrote my report, so it occurred on the 18th, 19th. I finished up my notes and the report. Okay, so after 2 days of working on it, right? That's correct. And you basically just leave all your work in the same place, and then, in this case, Mr. Keisler comes into your workspace and looks at the stuff, right? So, an analyst has their own personal workspace, and comparison scopes are shared amongst the different examiners because there's not enough comparison scopes between all of us to have our own individual comparison scopes. So, I'll give the examiner the evidence, and then they will use the comparison scope that I used. So, the answer is yes? Yes, it is. Thanks for the clarification. His verification was complete on the 19th, right? He wrote his paperwork on the 19th, but he completed it on the 18th. In less than a day? Yes. What are we talking? An hour? I don't know how long it took him to do it, but it wasn't longer than a couple of hours than I'm aware of. Happened pretty quickly, right? Depends what your definition of pretty quickly is. It depends, huh? He didn't go through all the steps that you went through, did he? No, he does not do the formal entire re-exam of the entire work product. He actually only does the comparative process. And you told me that you've actually verified other technicians' examinations. I have verified other analysts' work. Yes, I have. And you've come where there were times when you've come to different conclusions than they have, right? Yes, I have. And you suggested that you would do more testing until you both agreed on something, right? Basically, usually where disagreements can occur is between like individual or identification. This doesn't occur every day. It can maybe occur maybe once in a year or something like that. But if I am looking at something and I think that an identification could be made, I may ask the analyst to go test fire more so I can come to a conclusion. And if my conclusion ends up being different than their conclusion, then we either need to decide what I'm seeing. Is it different than what they're seeing, or have they not done enough to be able to, like, maybe they didn't alter the light enough, maybe they didn't test fire enough. So if they don't agree with me, at that point, it can go to another review process, which would be the supervisor and quality assurance. So there's no circumstance under which two human beings just agree to disagree, right? You can't just say, we just have a disagreement. We can have a disagreement. So if I disagree with them and they disagree with me, then that would go to the supervisor in the quality assurance process. At that time, the determination would be made by either the supervisor re examining everything and coming to a determination, and then that would all be reported out. At the end of the day, There is individual discretion involved in making these determinations about whether or not sufficient agreement is something something inaudible. She says, well, it is subjective, yes, in nature. And that is the big word in your industry. Subjectivity, isn't it? Yes, it is. And that's where the battle lines are drawn between the people who don't believe in this discipline and the people that do, right? Yes, there are people that believe that because there's subjectivity, it can't be a science. However, anything that involves a human has subjectivity. Right, but you're using your eyeballs to basically tell you, does that match or not? So it's a big difference than like doing a DNA test where, yeah, there can be tests, faulty tests because the people doing the test might contaminate it or whatever, but you're still getting a solid result. So if it wasn't contaminated by that human, then you would have a sound result. This, you can't even say that because it's just eyeballing comparisons of this versus that, and oh, that looks like a scratch there, so that might be a scratch that matches that scratch. I don't know. To me, that's what it seems like they're doing. But that's where the dispute is. Some people want to weigh and measure what subjectivity is allowed. I don't know how you objectively measure subjectivity, but that's where there's a dispute. Yes. What you see in any one of those photos could be different than what another lab examiner sees, right? There's a potential, yes. Well, not just a potential, it could happen, right? Yes, it could happen. And it does happen, doesn't it? It does happen. One second, please. Okay, with regard to this verification process, you told me back in March you've never had anyone disagree with your findings, not one time, right? I have not had anybody make me go test fire more or say, I do not come to the same findings as you do. So you've never had anyone disagree with you? Well, people always disagree with me. Just bring my husband. But not with regard to your lab exams, right? I can't believe she said that on the stand. Not the final product, no. How's Mr. Oberg feeling about that? Okay. You had earlier Mr. Luttrell in his presentation. Judge, may I approach? You may. Judge, I'm gonna just put some exhibits in, if that's okay. I've got defendants exhibits Q, R, S, T, U, and V. Can I ask a couple quick questions to lay a foundation? Q, R, S, T, and what? U and V. These are photos? Yes. Okay. Ma'am, just let me hand you, if I could, let me hand you what's been marked, and these are stacks of copies QRSTUV, and take a quick look at those if you would please. But those are all copies of the witness says of the like this one is a set. Okay. Yeah, see, it's Q. Okay. Sorry. I mean, you can look at them if you wanted to, but I think you're going to find that they're all copies. Yes. Now, are these images microscopic images that you're familiar with? Yes, I am. And at least in part, did you do these images accurately reflect the condition that existed at the time that you took those images? Yes, they do. And did you rely on these, at least in part, in coming to your conclusions in this case? I did not rely on the photos to come to a conclusion. But the information that's depicted in those photos, right? I don't make spaces, surfaces. I relied on the surface areas that I observed. Yes. Move to admit Q through V and publish. Move to admit first. Mr. Luttrell says, I do not object to them being used as for what purpose she has described them as, but there's no foundation that they can be used for analyzing her opinion or the results that she came to. She specifically did not lay a foundation for that if they're being used as representative of the areas in which she felt were relevant to her examination. But to be used to be analyzed and studied, it would be inappropriate. So that's the nature of my objection is the foundation that's been laid. So she took these photos. She took them in her examination, and now they can't even come in to trial. What? What are we doing here? So it's a foundational objection? Yes, Your Honor. Okay, what's your response? Mr. Rosie says, my response is she just said that she utilized the surfaces of these images to make conclusions. The court says, well, and as long as the jury understands that she clearly stated I do not rely on the photos to make a determination. I think they get it. That's fine. I think they can figure that out, says Mr. Rosie. The court says, so it's conditionally admitted. Mr. Rosie says, thank you. May I publish these, Your Honor? You may. You may continue. There are extras there, I think 2 or 3 copies, says Mr. Rosie. The court says, I'll take them. May I continue? Yes. Ma'am, when you receive items at the laboratory to be examined, do you receive a request form from the Indiana State Police that comes from the blah, 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 blah. Let me restate that again. Ma'am, when you receive items at the laboratory to be examined, do you receive a request form from the Indiana State Police that comes with that? Yes, I do. May I approach, Judge? You may. I'm going to hand you what's been marked as Defendant's Exhibit W. If you just take a look at that, if you would, real quick, and let me know when you're ready. Yes, I'm ready. Is that a 3-page request for lab exam report? Yes. And without getting into all the technicalities, those numbers, that top right number, that 17K number, is that this case? Yes, it is. And do you agree with me that you received this request for lab exam in conjunction with item 024, which is one of the firearms that you talked about earlier in your direct examination with Mr. Luttrell, directing your attention specifically to page 3, where that firearm is listed? Yes. Now, are these records that are generated in the normal course of business when you're examining receiving items? This was not generated by me, but it's generated by the agency who submitted it. So this would apply to your receipt of item 024, which was a firearm that was on the slideshow? Yes, it is. Okay. And just to be clear, because we've got a lot of names going on today, that's the black Glock 22 handgun, right? That's correct. And that was a handgun that you could not exclude? I did not exclude that handgun. I didn't find any individual similarities with it, nor did I see any class characteristics either. But you didn't exclude it as having possibly cycled that round, right? I did not exclude from it. So this other Glock gun is not excluded from cycling that round. So whose Glock is that? 024. I don't know. Will we find out? Will we ever know whose Glock that was? Judge, may I admit defendants W? Court says Mr. Luttrell. No objection. All right, without objection, W's admitted. May I publish? This is W? Court says W. May I publish, Your Honor? You may. Why does Mr. Luttrell was like, this is W? Okay. Handing you what's been marked as Defendant's Exhibit X. Is this the corresponding firearm examination worksheet for that same firearm we just talked about? Yes, this appears to be a copy of the examination sheet that I created. Same question, same answers about being conducted or prepared in the course of your line of work and presented to you? Yes. Mr. Rosie says, move to admit X. Mr. Luttrell says, just one moment, Your Honor. No objection. All right, without objection, X is admitted. May I publish, Your Honor? You may. The court says, Mr. Rosie, we're going to have to take a break. Mr. Rosie says, thank you. The court says, all right, well, ladies and gentlemen, we're going to go ahead and take a break while you're outside the courtroom. Please keep your minds open. Don't discuss or don't form any final opinions or conclusions about anything. You may discuss the evidence that you've heard so far, but please only do so if all 15 of you are present. Remember, we lost a juror yesterday. If all 15 of you are present in the jury room at the same time, and please don't deliberate. Gentlemen, all rise. The court says, all right, let's take 15 minutes and we're going to go off the record. And that is where we're going to end it today. We have one more episode of Miss Oberg on the stand before we conclude hers. And then after Miss Oberg, so the next episode, 26, is going to be Miss Oberg's up next again. And then Lieutenant Jerry Holman is going to be up next. So that is what you guys have to look forward to. So we will continue on next week with the continuation of Melissa Oberg. And after that, we will start Jerry Holman's testimony. So thank you guys so much for watching, and I will see you in the next one. Please don't forget to hit the like button on the way out. Take care, guys. Bye now.